Hello, and welcome to Law Talk. My name is John Celebrezze, and I'm the co-founder of the Celebrezze-Zange Community Legal Education Project, as we call it, CZ-CLEP for short. Our organization provides continuing education about the judiciary and legislature to attorneys, judges, government officials, and the general public. As a career educator, I recognize early on how important legal matters are and how they impact our lives. I am the nephew of the late Anthony J. Celebrezze, who was the popular five-term mayor of Cleveland and a member of President Kennedy's cabinets. As a tribute to his lifetime commitment to the legal process, we dedicate this show. Our guest today is Chase Carter, recent winner of the Ohio Northern Law School's Anthony J. Celebrezze Appellant Advocacy Competition. Having just completed his second year of law school, Chase is from Bainbridge, Ohio. He is a graduate of Capital University, where he majored in political science and public administration. At Ohio Northern, Chase is a member of the 21st Amendment and Criminal Law Societies, along with the Student Bar Association Election Committee. He was a legal intern at the Ross County Prosecutor's Office and plans to open a private practice when he graduates from law school. Welcome, Chase.
Thanks for having me.
And on top of that welcome, a big congratulations.
Well, thank you.
I think it was pretty exciting to see you take it home in the last round. I'm sure Uncle Tony, as we affectionately call my uncle, who the competition is named after, would be very proud of you. I thought it'd be good to have you on the show today. I think many of our viewers, of course, are very interested in all aspects of the law. We have judges and lawyers on a pretty regular basis, but you're our first law student.
Okay.
We've never had a law student on before, but the law school process is very much a big part of becoming a lawyer. I mean, having undergone that myself as well. So, if you don't mind, I was going to ask you a few questions. I got my trusty clipboard out here.
Okay.
And maybe we could, we'll sort of recap what happened that day for you, April 15th, 2010. And I was fortunate enough to be there representing the Celebrezze family. First of all, Chase, for the benefit of our viewers, what is the appellate advocacy competition at Ohio Northern?
Well, it's a competition based on an appeals case. It's usually a real case based in some series of facts. This year was the case was based on McDonald v. City of Chicago, which was a Second Amendment case.
I see.
It's open to all second and third year law students. It's an open sign up. You just basically put your name and information down, and then about a week to 10 days later, you start your arguments. So they just basically give you the question, and you're free to go wherever you want from there.
I see. So any of the students there at the law school it doesn't matter which year you're in, or?
As long as you're 2L or higher.
2L.
Yeah, the first years aren't.
Okay, that's right. First year wouldn't be applicable, but 2L meaning second year law student. So, well, gee, then you were, again, congratulations. You won it as a second year student. Mm-hmm. You going to try again?
Probably. If it's an area that I'm the least bit interested in, I'll definitely try again next year.
More power to you. Maybe we'll have you on the show again next year. So, to win on April 15th, you had to prevail throughout a series of rounds. How many, Chase?
There were 5 total. You had 2 preliminary rounds, which were argued in front of the Moot Court Executive Board. Then you had a quarterfinal round, which was argued in front of 1 faculty member and 2 members of the Moot Court Exec Board. The same with the semifinal round. Then the final round was argued in front of Judge Wilimowski, Judge Bryant, and Dean Crago.
I see. Wow, it's quite an endurance test, as well as taking all your classes while you were doing this. Must have been somewhat of a time commitment to you.
It's about 3 weeks to get through the whole process. The preliminaries are on Saturday and Sunday. Then after that, they were, I think, every Wednesday.
But to prevail, you had to make it through 5 rounds.
Yeah.
Okay. Wow. I think you answered this question. I mean, the other part of my question was, were different judges for each round, which the answer is yes. Kind of a conglomeration of faculty members, board members, and then the three gentlemen that I witnessed you argue in front of on the 15th are actually judges I personally know, not that that's of great significance, except for the fact they are real judges. Judge Wolomowski sits on the Court of Appeals now. Judge Bryant, I believe, is retired.
Yeah, he retired, I think, 2 years ago or last year.
Yeah, not too long ago. He was from the district right in the vicinity of Ohio Northern there. And then, of course, Dean Crago, who, of course, has extensive background in law. That was pretty interesting. That was an interesting interaction of the judges, and when they came out and critiqued you, and of course, you probably figured this out, but those of us that didn't go in with you were all out on the outside giving our own Monday morning quarterbacking as to who won. I'm not going to tell you who I thought, but in this particular competition, which I guess is pretty much typical of all of them, but I think for the benefit of our listeners, you were the petitioner in this case. What does it mean when you're the petitioner?
Well, whenever there's an appeal, there are two parties. Some courts use different names. Some use appellee, appellant. Some use petitioner and respondent. The Supreme Court uses petitioner and respondent. Basically, the petitioner is a person seeking a lower court's ruling to be overturned. In this case, this would be in the current case that we were talking about would be the gun owners. The district court had ruled in favor of the city of Chicago. The gun owners appealed to the Supreme Court, making them the petitioners. They were the moving party.
I see. Well, you're kind of bucking the tide.
Yeah.
I mean, other courts below where you're at, and this was the equivalent of a Supreme Court case, have ruled the other way.
Right. Okay.
And pretty good win for the competition, pretty good win for content as well. So the case was on the Second Amendment right to bear arms. And as you said, the city of Chicago apparently has some restriction on that. As you say, the gun owners would be the people you were representing. I guess I'll birdwalk just a little bit here. We talked briefly after the competition. Do you have a personal interest? Are you a hunter? Or?
Oh yeah, I grew up in a small town in rural southern Ohio, where every weekend, every evening, it was pretty much from the time you were old enough to go out on your own or go out with your family members. Everyone hunted, everyone shot, everyone fished.
So guns have been a part of your life from the time you've been a child. I see. Okay. Well, the Second Amendment has been the focus, as I have in my notes here, of other moot court competitions. I actually have witnessed at Ohio Northern. I'm sure they've gone on other places. Pretty hot topic. I mean, why do you think?
It's one of those issues that everyone kind of has an opinion on at first glance, because everyone that's taken a civics class in elementary school, middle school, high school knows the Second Amendment, which when you first look at it looks pretty plain. But as you start to see how the judiciary, the legislature, and other branches of the government have looked at it, it becomes extremely complex and extremely murky. A lot of the decisions that I used in this competition were the same cases that my opponents were using, because they're so vague.
Sure.
You can argue pretty much either side using the same case, like the Miller case.
Yeah.
It's just so complex that it tends to make a good moot court topic, because one, it gets public interest. If someone sees that it's going to be a Second Amendment issue, you're going to have a lot of people just come out just out of curiosity. It's also going to get a lot of very heated debate, because it's an issue that so many people hold dear or so many people bitterly oppose. It's something that it just lends itself to debate and lends itself to moot court to get both sides of it.
Apparently this one isn't settled yet then.
No, it was actually submitted. The oral arguments were held before the Supreme Court, I think like March 3rd or 4th, very early on in March. So we actually had access to a lot of the oral argument pieces from the actual case to kind of build our stuff on.
Yeah. Well, in that the real McCoy is out there. I mean,
Mhm.
albeit maybe what you did was an academic experience, but nonetheless, the facts were all the same, and the law is yet to be made. I mean, I guess that's what this is all about, right?
Yeah, they're predicting it's going to get ruled upon to be the first case when they come in session in the fall.
I see. And again, the caption on that case is?
It's McDonald v. City of Chicago.
McDonald v. City of Chicago. For those of you that follow this type of legislation, it's going to probably be landmark. I mean,
Yeah, it will be depending on how it comes. Well, either way it comes down, it'll be the Second Amendment case.
There's a legal significance to what you did and what the Supreme Court has to do here, and maybe from the perspective of a guy who had to stand and deliver on this particular topic, what is it? What do you think the legal significance of?
It's a really landmark case. It's something it's novel, especially in the modern court. Incorporation is something that's been around since the late 1800s after the 14th Amendment was ratified, but it's something that the court never really picked up until the mid-1900s, and it's been something that they've selectively used throughout probably about the last 100 years. And with this case, it's basically trying to incorporate, which is, in as simple terms as I can put it, allows someone to be protected the same way with a right as they are from the federal government as they are from the state government. Incorporation actually basically binds the states the same way the federal government's bound by the Constitution.
I see. That might be something a lot of our viewers don't really understand.
Yeah.
But so when we start out with the Second Amendment, which has to do with our right to keep and bear arms, that all came about in the Bill of Rights, our first 10 amendments, by our founding fathers, federal level,
Yeah.
United States government. But we live in a democracy that recognizes both federal authority but then state and local authority.
Yeah.
So somehow the 14th Amendment permits those very same rights, if you will, in the first 10, or some of them, to the states.
Yeah. It's something that a lot of people don't realize, that when you learn about the Bill of Rights, up until really the late 1800s, those only protected a citizen from the federal government. The state government still pretty much operated with impunity.
So without landmark cases like you most recently argued, that would mean that the state of Montana could probably let you do about anything you want with a gun, not to be stereotypical, but it's a kind of a rural state and whatnot. In the state of Illinois, which had to do something with your case, Chicago, could have really, really constrictive gun control.
Right, which is basically the heart of the issue in that case. The city had passed an ordinance that required all firearms to be registered. Anybody that owned a firearm had to carry a permit issued by the city. The problem became when they went to license firearms, the restrictions were extremely tight. Handguns could not be registered at all. There was no way to possess legally a handgun within the municipality of Chicago. You also had to possess the gun before you registered it, and it had to be in your possession outside of the municipality. Like, say, for instance, you order a gun through a catalog or off eBay or Amazon, something like that, and it ships to your house. The instant you pick that box up, if you're in Chicago, that gun became illegal. You couldn't register it from then. That's what the petitioners were trying to get overturned.
So there was another case, actually it was argued at when you were a first-year student, dealing with a Washington law, which the Washington, D.C., which the court actually ruled upon.
Yeah, the Heller case.
There you go, the Heller case. And